There we go. This is LAWS12066, and this is the last tutorial for 2014 in land law, and we're going out on a bang. Topic 11 on social housing, and then I'll make a few observations about the final assessment just at the completion of the class. Just for both of you, Aisha and Grant, and also for any of those who's listening to the recording, we did have a class earlier today, or I did have a class earlier today, and I recorded that on topic 10 on freehold covenants, and that's now been uploaded to Moodle, so you can review that at your convenience. Now, this topic on social housing, this is really, you know, a bit of an innovation by me. It's certainly, I mean, it's probably pretty evident from the notes that this is a keen area of interest of mine. And when I originally wanted to design this course, I certainly wanted to find some way to incorporate something about social housing, because it's really not dealt with adequately, in my view, in standard law courses for law students around the country. That's the truth. And yet, you know, I mean, traditionally, of course, property law has been about the relationship between private parties in terms of dealing with matters of property, items of property, and we've seen over the course of the year that embraces both goods and land, and we've had, you know, obviously quite a focus on land, not only in this course as we need to, but it even started earlier in term 1 for those of you that did foundations with me. But you may, I'm sure you have, picked up on a resonating factor. There's this underlying idea about the how do we deal with the public aspect, or the public space. What are those obligations there? What is appropriate, and so on and so forth. In traditional land law courses, and the topics which we've traversed mostly throughout this course, not necessarily always in a traditional way, but we've certainly traversed the material which is necessary and important in terms of your land law studies. But a lot of that has essentially been in relation to private dealings between private parties in relation to interests in land. I mean, certainly back in, again, foundations, we looked at native title, and we, of course, touched on that in terms of the Native Title Act back in topic 1. And that is a different emergence of how we understand the nature of relationship to land and the interests that can be held in that regard, in that context, for native title holders, and what that means and what rights they have under now the amended Native Title Act. But all of the preceding topics have essentially been dealing with these various aspects of interests and the nature of those interests, and how the law understands those interests between private parties. This topic is taking us centrally to the idea that not everybody in the society has access to private land. Not everybody is within the social or the economic circumstances where they can have an interest in land, or they can exercise those rights with respect to land as a private person or a private entity. And they are very much reliant on the government of the day or the public sector to respond to their housing needs and to respond to their accommodation needs. And there is a section of the community and the society there that cannot even, do not have the resources or the facility to be able, for example, to even afford private rental accommodation themselves on their own behalf because of their economic or financial and social situation. And this can embrace and does embrace various aspects of persons in the community who are suffering disadvantage in a number of ways. Historically, we've seen that that's been responded to through public housing, and the early part of the notes documents the response and the development of public housing as a policy of the federal government from 1945 under the Chifley national government, with the development of the first Commonwealth State Housing Agreement in 1945, which was a 10-year agreement. And that was, post World War II, and there was a, desire there to deal with the issue of how do we provide accommodation in a way for returning servicemen, but also people that just were needful. And there was a public housing strategy in place. Over the period of decades since the first Commonwealth State Housing Agreement in 1945, there's actually been a shift away from a public housing policy initiative to what is now essentially a welfare housing initiative. So that we are now, or the state and the governments of the day, Commonwealth and state, but state and territory governments have provided the accommodation resources, dwellings, but there's been funding from the Commonwealth, and then that's been generally allocated and utilised by state housing authorities and agencies to what was essentially, it was still called public housing, but to provide essentially welfare housing for those members of the community who were in circumstances where they basically could not get access to housing through their own private means. So that was different to the idea that everyone was entitled to some form of basic accommodation, and the Commonwealth had a role to play in that, and the government had a role to play in that. And there's arguments in different directions philosophically about how much government should be involved and what type of involvement they should have. Now, as I posted a response to your response to the problem questions for this topic, Grant, and you can have a look at those, and others can as well. Basically, a shift occurred around about the mid-1980s with the Hawke federal government, where basically we saw the development of special programs, and one of those special programs identified this thing called community housing. And it was from that point, from the mid-1980s coming forward, so we've now got 90s, 2000, so about 30-year period, we've found the emergence of this community housing, and community housing basically has developed as a form of social housing, which is government, has historically been, since it was emerged at that time, government funded, but actually the housing stock has been managed by community housing organisations, community housing providers. When we talk about social housing, we're actually talking about the array of government-assisted housing that isn't private housing, and it can include public housing that's entirely owned and managed and administered by public housing authorities or agencies, community housing, which can include long-term community housing, where community housing organisations or providers are responsible for managing the housing on an ongoing basis with their tenants, There are also specific types of community housing that are more specifically identified and they don't fall into the category of long-term community housing for Indigenous peoples, Indigenous Australians. And the Commonwealth also developed a program for dealing with crisis accommodation, and that was a response, particularly during the 1990s, to crisis, if you like, in homelessness, and then a bit further down the track, there was a further aspect of that that also targeted youth homelessness. But those were different. They were different government responses to social problems and concerns, and arguably forms of community housing or social housing certainly, but not part of what was considered to be long-term community housing. And basically responses were different and for different time periods and so on and so forth. What we've found emerge in the more recent period, and that when I talk about the more recent period is probably post post mid 2000 and beyond. So in the last 5 to maybe 5 years, 8 years, we've found a more entrenched and a more refined community housing sector across the various jurisdictions, states and territories. We've found an amalgamation of those providers so that we've got fewer providers and larger providers. Most of them are jurisdictionally based, Queensland, New South Wales, Victoria, so on. There is funding coming, or funding has come from the Commonwealth, and since the Rudd federal government in 2009, under the National Affordability Housing Scheme, which replaced the former Commonwealth State Housing Agreement strategy, there was a clear emphasis on that funding provided by the Commonwealth to be directed towards community housing providers rather than state housing agencies, the belief being that community housing providers were more in touch with the needs of their ultimate tenants, and they could actually better manage and deliver that housing, that accommodation service to those tenants than bureaucratised state housing authorities, which had become quite detached and removed from their tenants, and there were significant issues arising in public housing and the management of public housing stock across the jurisdictions. So from 2009, with the new funding strategy by the Commonwealth, we found a heightened emphasis and focus on community housing providers being able to do things in the belief of the government better, more effectively, and with a more genuine response. In the very recent period, the last couple of years, 2 to 3 years, I suppose, there's been, or 4 years, arguably, I suppose, there's been a lot of suggestion that, well, that's fine, but what we really need is we need a more robust strategy of regulation and registration of these providers to ensure accountability, to ensure standards, and so on. And so what we've found has emerged and been enacted as legislation, but only, and you've seen the documents that I've given you on the under this topic on the course website, only as recently as this year becoming effective, but not necessarily effective in all the jurisdictions immediately from the 1st of January 2014, but a new national regime under the Community Housing Providers National Law. But that national legal framework takes effect as through legislation enacted in the jurisdictions, with the qualification that it only applies to participating jurisdictions. Not every state and Commonwealth in Australia is a participating jurisdiction. Queensland is a participating jurisdiction, as is New South Wales, as is South Australia, as is the ACT. The other states and territories have not yet signed up or may not want to sign up. And even those states that I've referred to, and territories, the ACT, and I think the Northern Territory might be on board, but yeah, I think they're sort of almost there as well. But those states and territories, even though they've signed up to the national law in terms of the framework of regulation and registration, they still have their own way of dealing with aspects of the framework. And in particular, which is particularly relevant for what we're concerned with in a land law course, the issue about who owns these properties and where title sits to these properties that are ultimately going to house community housing tenants has been a contentious and a fractious issue, and there's certainly not consistency across the jurisdictions in that regard. New South Wales now, there's a long history of obfuscation and resistance, I think, fair way to put it, but now I think is the innovator, clear innovator in this area, through provisions in its legislation which adopts the national law, but it enacted this even before then, where it has vested title in public housing properties to community housing providers for the purpose of providing housing to community housing tenants. And that's basically, short-circuited in the sense of it's changed gear in terms of the situation, but how that's going to work itself out is yet to be seen. In Queensland, that's not the case. And if you were to look at, you can open this up at this point if you want, and we'll come to the tute problems shortly once I've completed these overview remarks. But if you open up the Housing Act 2003, which incorporates the amending provisions from the Amending Act 2013, you will see that there's nothing there about the vesting of title in properties to community housing providers. In fact, none of the amending provisions refers to that, and you need to actually go back to the powers of the Chief Executive Officer to see that those powers include the capacity to lease properties. And so the arrangement of the continuation of community housing providers in Queensland only being responsible at this point. There is some statements by the Public Housing Authority on its website and in some of its documents that it's developed that might change in the future. But at the moment, it's the case that those providers are still only managing the housing stock that's owned by the Commonwealth, the Queensland Agency on behalf of the Queensland Government, public properties. But the other thing that's happening in Queensland is that I think there is the clear intention for community housing providers to almost take over the management of public housing in Queensland in a way that hasn't happened previously. So there's a reform and an innovation happening in Queensland, but it's not going as far as it does in New South Wales. South Australia has recognised giving title to community housing providers since the early 1990s, but the mechanism to secure the public interest through what was historically referred to in the South Australian regime as a debenture scheme actually put significant levers of restriction on providers to such an extent that it actually almost neutered the title which they had under the legislation that was in place there in South Australia. But South Australia has now adopted the national framework as well in 2013. So we'll see how things emerge there. In New South Wales, with the vesting of title to providers, the public interest is being preserved through the mechanism of a charge over the property, where there is a public interest in those properties. And then this opens up the Pandora's box with regard to access to finance and funding, finance, borrowing, loans and so on against the property and against title, which historically community housing providers have not been able to do, in the same way that the private owners can do. But of course, with a registered charge on the property, of course, you know, financiers then have to look at that. But of course, it's a different scenario. It's not actually private accommodation. So there's a need to coordinate here between the government of the day, the community housing provider organisations and financing organisations or potential lenders to try to leverage finance into the sector to grow the sector and grow the housing stock. So that's a different scenario to a private individual or a private entity going to a financing organisation for a loan and then that being secured by mortgage in the usual ways, as we've seen in the property law implications of that. Right, so there's some overview remarks. Have either of you got any comments to make or anything to say at this point?
Yes, I do. Not that much actually, because I've only scanned over the notes. So this week I haven't done the tutorial questions. So I think that I'll be listening more so this week to you and Grad.
It's fine. It's fine.
I've read the notes. I haven't read a lot of the attachments though. Actually, with what you've just said, it certainly clarified a few points, because what I was perceiving as community housing, I was thinking of community housing is social housing. Obviously, there is a distinction there. And I've thought of social housing and thus community housing as welfare sort of housing. But this is going to get a bit off topic. But obviously, it's a very big social problem. But when I look at these organisations and the potential benefits that they can bring, because they are sort of more in touch with what they're trying to do and with the community and the people that they're trying to help. Just a general observation, and this is really a question back to you, is in terms of whether you see a solution to it and what you think the solution is. But when you look at public housing or community housing, where sometimes disadvantaged people are provided with this housing, and then the communities and whether the socio-economic groups or whatever the case may be, but that over time, the properties, as they deteriorate, as there's crime and the areas get worse, and it seems to gravitate and bring more people into those areas where it seems to progressively decline. Just a general observation, I've never sort of really seen a solution in terms of social housing that has seen these areas improve in terms of the wider community. As I've seen, and I've sort of witnessed areas where there have been houses purchased for community housing, and then over time, whether it's over 5 years, 10 years, the sort of the social problems that then gravitate to it, it just doesn't seem to. I just don't sort of see what the sort of the end solution is and what the end game is. There just doesn't seem to be something coming out of it other than it's an immediate solution to provide a roof over someone's head. But then what's the long-term solution to change sort of the social conditioning of of people who are in these situations?
That's all good questions, Grant. Aisha, have you got any thoughts on any of that? Just generally?
Yeah.
Just generally.
Yeah, sure. Just what Grant was saying before, I understand his point, and I agree with what he said for the most part. Although it's difficult to it's not difficult to make the distinction between possible social problems that occur generally in, say, lower socioeconomic populations and social housing itself. But I thought just with this particular issue, we were concentrating on just the property part and providing housing. Yeah, I'm not too sure on that, but I do know that my experience with social housing or community housing is basically where the state, say the Department of Housing or something like that, has on offer certain residences or certain property for people. So I think from scanning through your notes, I think there was some move towards changing or giving the title to community-based organisations. Yes. So that would be a very interesting management move, I'd say.
Yep. Look, thanks for both of those observations. Can I, before I respond to that, I just want you to, if you've got you're at your computer, so can I just get you to open the document on the website under this topic, Housing 2020, which is basically a strategy document of the Queensland Department of Housing and Public Works.
I've got it open, but I've not read this document yet.
No, that's fine. That's fine. I'm going to direct you to something. Of course, in light of those comments you made, Grant, the first picture that you see on this government document is of nice, glowing, new dwellings that look wonderful and new and excellent. Not all government-assisted housing looks quite like that, and particularly public housing, publicly managed, publicly owned housing does not necessarily look like that. There's plenty of, if you like, and I want to make the clear distinction here between public housing and community housing, and I think much of what you've been referring to, Grant, and even Aisha made the comment, is public housing, that is publicly owned housing, and housing that is managed by large bureaucratic public housing agencies. In New South Wales, the Department of Housing, prior to that, the Housing Commission, the Queensland Act 2003 even refers to this old nomenclature of commission, Housing Commission. And I'll just come back to the historical origins of that in a moment. But what I wanted to take you to, just to give a bit of context, responding a little bit to your observations, Grant, is firstly the diagram, or a pie chart really, on page 4 of this document. And if you just scan down to page 4, it shows you the distribution of housing tenure types from the 2011 census. Now that's obviously, it's 3 years out of date, but there hasn't been a land shift in percentages very much since then. You can see there that about 64% approximately is owner occupation. Okay, it's home ownership. It's owner occupation or leading towards owner occupation. and then there's about 30, a third of accommodation is private rental accommodation. And this proportion that we're focusing on in this topic is 3.3%. So at this stage, it's still very small in terms of the total percentage of housing stock, in terms of how people are accommodated and how they're housed. Now, when you look at that figure of 63.5%, that's pretty accurate, but 64%, whatever. One needs to put that into historical context. And today, many of us tend to think about home ownership as the norm, as the standard for much of Middle Australia, Middle and Upper Australia in terms of their social and economic circumstances. But the truth is that this egalitarian, generally, I think in the last few years things have gone a bit berserk in terms of the idea of everyone having access or able to get access to home ownership, where because of the pricing structures it's gone crazy, particularly in metropolitan cities around Australia. But this notion of home ownership for middle and upper Australians, middle class and upper in the Australian structure of our community and society, really only emerges since that first Commonwealth State Housing Agreement in 1945, where that agreement not only provided the basis for a public housing strategy, but it also put in place structures to encourage affordable home ownership, actually. Initially for returning service personnel, but going forward through the various iterations of the Commonwealth State Housing Agreement, which was about funding allocations, then it was about this balance, and particularly in later iterations of the CSHA under Conservative governments, there was a clear emphasis in the direction of home ownership. Prior to that, large sections of Australian society were not involved in home ownership or house. It's interesting we call it home ownership, isn't it? Rather than, we don't talk about house ownership. We talk about public housing and social housing. We don't talk about house ownership, though, do we? We talk about home ownership. And it's interesting that, because there's a different implication, in my view, and the literature supports this, when we use the word house as opposed to when we use the word home. Home suggests a whole...
I agree with you, Michael.
Sorry?
I agree with that. I think there's a different interpretation of both words, house and home, as well. Absolutely.
And so, again, using our critical eye, we just need to pick up on these things. And even in that diagram I'm showing you, home ownership and social housing. We don't talk about social homes. We don't talk about it. You might think it's a small point, but actually I think it's more significant. So that idea of everyone, if you like, everyone in the community and the society being able to access ownership of their dwelling only really emerged in the last 60, 70 years. Prior to that, that wasn't the case. And also, we have in Australia divisions between metropolitan areas, regional areas, and rural areas. Now, to cast your mind back earlier in this course, and I know, Aisha, you weren't with us at Foundations, but in Foundations Property Law, we also looked at pastoral leases. I gave you a document in the leases topic on a recent version of a pastoral lease introduced in Western Australia going forward, a more modern version of that. But this whole idea of pastoralists those that went out into rural areas and took holdings of land and developed the land with grazing or farming and so on and so forth. They really were extending the reach of what they did, and in some respects not necessarily legitimately. However, over time they sought to self-legitimate what they did, and then oppose other interests that challenged what they had done. So that was out in rural Australia. Okay, and there's still, of course, as you know, large tracts of rural Australia subject to pastoral leases. And in a pastoral lease, you don't own the land. It's a lease, statutory lease, as we've come to understand, from the Crown. So large tracts of vast areas of this country are subject to that form of tenure. Then we move into regional Australia and metropolitan Australia, and we find that the idea of owning a dwelling, mostly if you're talking about, let's not move into the commercial sector, but in the residential sector, that's what we're focusing on in this topic, then the idea of owning that dwelling that one is going to live in has emerged as a very strong idea, resonating idea within the society, within the community. But within a residential context, mostly, of course, most individuals and most groupings of people or families, whatever, they can't do that on their own because the costs and the funding required, they don't have brown paper bags of hundreds of thousands of dollars sitting around. So, of course, they must borrow money from financial organisations, and then mortgages are entered into. So what this emphasis on ownership has actually led to is an entire industry of financing to support that ideal or value of home ownership. And it's been a great boon to the financial sector because they make an awful lot of money out of financing the purchase of dwellings. But, of course, the owner does get, under the Torrens system, as we know, the benefit of protection, of ownership and these sorts of things. So the point I'm making is that this has only emerged in the last 60 to 70 years. Now, coming back to Grant's point about some of the issues that arise, and yes, we are focusing, Aisha, on the dwellings and housing and the structures and processes for regulating that and those that provide that and those who have access to that. But just to comment on Grant's point, those problems, those issues, and also to some extent you might argue that the ghettoisation in communities of state-assisted housing really have more plagued public housing estates and public housing dwellings. And one of the reasons is that because, as I mentioned just in my opening remarks, we no longer actually have a genuine public housing strategy, even though we call it public housing. And this is not community housing, but public housing. We no longer have a genuine public housing strategy. It's actually welfare housing. So what's actually emerged in the more recent time with public housing stock is that we actually have housing that is owned and managed by large bureaucratic government agencies, with all of the attended problems and issues of a large bureaucracy trying to do that and deal with people's lives and deal with the dwellings that are housing them and maintaining them and so on. And often not the wonderful new shiny stock that we saw in that Housing 2020 strategy document, but actually crumbling stock or inappropriate stock and out-of-date stock that hasn't been updated or modified because there isn't more public money to do that. So the management of that stock, but what we've got, because it's actually in truth and in reality welfare housing rather than public housing, all of the tenants, all of the public housing tenants in that housing stock or in those dwellings are people of need, people with issues, and they're all congregated together rather than a diversity, which you might find in the broader community. And so that tends to exacerbate problems and issues, and that then leads to further complications. But that's public housing, which is a part of social housing. But then there's community housing, which is actually different, and it is still offering housing to people with social and economic needs or disadvantaged. But the housing stock is being managed, or indeed in New South Wales now owned, by community housing providers, community housing organisations. And the relationship there between the community housing organisation, either as owner or as social housing landlord, and their tenant is quite different. And because it's quite different, you actually find the outcomes and the way the stock is managed, the way that it is maintained, the relationship with tenants, and indeed the whole situation is actually quite different. And there's been plenty of examples of where and that's actually why there's been this shift towards community housing providers, because plenty of examples of where they've actually taken over public housing stock and public housing estates, and they've turned them into success stories because of the different way in which they do everything, and because of the more organic and grassroots relationship, if you like, between the social housing landlord or the social housing owner and the ultimate people that are being housed, or the tenants in that accommodation. So let's move across, because I can't stay forever tonight, unfortunately. I'd love to, but I've actually got to go and pick up one of my sons from basketball training. So just get to the problems, the tutorial problems. So problem 20, explain how community housing is different to public housing. Is all government-assisted housing other than public housing best described as community housing? Well, I've really addressed that in my opening remarks. Grant, you posted a response to this. Do you want to make any brief observations in light of what's been said so far?
My brief remarks are that I need to reconsider my response.
Okay. That's fine. That's fine. So, look, I mean, the long and short of it is that community housing is different to public housing. Okay, it's different to public housing. Both are government assisted financially or in terms of housing stock, but fundamentally different in the sense that community housing is being either today, in 2014, owned or managed by community housing organisations. Mostly managed, but in New South Wales, they are now title holders, and that's quite radical. Is all government-assisted housing other than public housing best described as community housing? Well, I addressed that in my opening remarks, in that, you know, again, this is an area that a bit specialised, I suppose, but one can talk about community housing in a broad way in terms of government-assisted housing that's being managed by non-government, independent non-government community-based organisations. But you can differentiate between various forms of that, and the regime of regulation under the new national law is really focusing on long-term community housing, and there are other specific initiatives dealing with other types of accommodation needs, crisis accommodation, homelessness and so forth, that the government, Commonwealth, has initiated and which the state also responds to, which is still distinct. One of the things that, you know, one needs to understand here in this area, as in other areas, is that the historical relationship that's emerged over time in the Commonwealth of Australia between the feds, what I call the feds, and the states and territories, is the feds, since those early High Court decisions that basically said that, you know, it closed off the avenue of primary taxation for the states, at that time only the states, subsequently the territories, and basically put that in the hands of the Commonwealth, so that essentially, basically, the Commonwealth has become the major money bag in terms of federal getting access to taxation and so on, whereas the states then have been left with minor and less significant ways of raising revenue. But the states and territories have continued a role of administering government programs to a very large degree under our federal structure. But what we've seen happen in the area of housing is a breakdown of the success of them being able to do that. And this is where we've seen the emergence of community housing providers as more in touch with the needs of their tenants, as more at the grassroots level, as smaller entities, as being able to respond more quickly and more effectively to the needs of housing, stock, changes, maintenance, so on and so forth, have a more direct relationship with their tenants than any large bureaucratic housing agency could ever possibly achieve, even with best intentions. And so that's how that's emerged over time. Problem 21 is getting you to think about the new national framework, and Part A about the Community Housing Providers National Law. Grant, did you want to make an observation about that?
Really, the only observation is that just conceptually, which I touched on in my response, and I think you've touched on it as well, that the whole point of shifting away from the government-controlled housing is to cut out some of the red tape and to get down to the grassroots, so that money can be spent where it needs to be spent, not based on someone sitting 1,000 kilometres away making decisions on something that they had no idea what they're looking at.
That's right. That's right. Having said that, just moving to one side, Indigenous housing is a separate area, not really addressed by this framework, and there are separate agreements and separate regimes in place for managing Indigenous housing. But unfortunately, and with great sadness, again we see a sense of inadequacy in dealing with the needs of Indigenous people in that area. And often we see the intervention of a plethora of government agencies who basically achieve very little, and the situation of the Indigenous people remains unchanged. Now, just as a further aside issue to that, what's interesting is just a further comment on this idea of home ownership as opposed to having access to accommodation but not necessarily owning the accommodation in ways other than private rental. One response to a needful community is that, well, you need to provide them with appropriate accommodation and shelter. I mean, the United Nations Habitat Conference 1 and 2 have, clearly specified, and in the Commonwealth State Housing Agreements and the National Affordability Scheme framework, it's clearly specified there of the basic human needs to accommodation and so on. But one of the interesting points that, for example, Noel Pearson has tossed up with regard to Indigenous housing is that, well, we need to move away from this welfare focus and we need to encourage a sense of self-responsibility. And one of the ways to do that is through the idea of ownership. So that's interesting as a different take on this. And the movement, for example, in New South Wales in community housing, not Indigenous housing, but in community housing, long-term community housing, to give title to the community housing providers. I firmly believe this will not only be about leveraging finance and funding into the sector, but as we know, as a homeowner, one takes responsibility in a way that is different than if one is not an owner. I think this will be a game changer, really, and we'll see how that emerges. So, but the basic strategy of the Community Housing Providers National Law is that it basically sets up a national regime of regulation and registration of community housing providers, but it has to be said only for participating jurisdictions. Not all jurisdictions around the country are throwing the hat in the ring, and so only for those that are involved, but that's the move. And there were regimes that preceded this national regime at state and territory level, and they'd started to emerge where, you know, in New South Wales, Victoria, we had registrars of housing developed under state legislation before this national regime was implemented, putting in place mechanisms for improving standards of regulation and registration and accountability of these providers to basically make them professional outfits that can do the job, and there's accountability for what they do, and the public resources that they're managing and the public monies that they're spending on behalf of the state, if you like. So the national law is an emergence of this in terms of one framework for all of participating states. And then the second part of Problem 21 basically takes us to the fact that the national law framework emerges as state and territory based legislation in the various participating jurisdictions as a part of that compact that's been nutted out. And in Queensland, initially that was through the Housing and Other Legislation Amendment Act 2013, but which has now been incorporated into the Housing Act 2003. It's interesting, in Queensland, they haven't picked up on the national law nomenclature. If you go back into the notes, for example, you will see that in South Australia, they've incorporated that, you know, the reference to the national. Also, for example, we now have in South Australia the Community Housing Providers National Law Act 2013, and in New South Wales we have the Community Housing Providers Adoption of National Law Act 2012. In Queensland, that hasn't been included into the name, and one of the reasons for that is that because the Housing Act doesn't only deal with community housing and this national law, it also deals with the administration and the apparatus of public housing as well. So Queensland hasn't gone the way of enacting separate legislation dealing with this, like these other two jurisdictions have, but it's incorporated it into its one act that deals also with public housing. So where do we find ourselves in sum? Basically, we find that we now have a national regime of regulation and control and registration framework for participating jurisdictions under the Community Housing Providers National Law, which manifests as legislation at state and territory level enacted by those respective parliaments. And we have different approaches between even the participating states in some aspects and strategies of how that gets implemented practically. And in particular, the issue about title to properties that are ultimately used to house community housing tenants is dealt with differently in the different jurisdictions. And in Queensland, under the Housing Act, we still have a situation where the stock is basically public properties owned by the government of the day or the agency that represents the government of the day, but managed by community housing providers. And that those providers will also start to take a much larger share of managing public housing as well as this so-called community housing. Whether that emerges as suggestions on the department website and some of their documents that there will be moves of in the future with regard to title going to these organisations, but that hasn't yet emerged. The situation in New South Wales, hard fought and hard won, and I can tell you from personal experience, having had involvement in the sector over many years in different ways, hard fought and hard won and much resisted for a considerable period of time. But the radical move to gift or to vest title to community housing organisations, I think, is a circuit breaker, and we'll see how that emerges. From a property law and from a land law perspective, very interesting, because now it means that those organisations will be the title owners and they will be the registered proprietors under the equivalent of the Land Title Act. In New South Wales, it's the Real Property Act. And in the New South Wales Act, the mechanism to secure the public interest and the public investment is through a charge. It's referred to as a charge, but it links to mechanisms in relation to mortgage provisions in the Real Property Act. So that's quite interesting. And I have a particular interest in that, having a foot in both camps of land law and community housing law and regulation. There's a paper of mine, as you can see from the notes, which is published article, or hopefully soon to be published article, emerging on much of this. And I've had quite a bit of interest in this for many years in many ways, including research and so on and so forth. All right, so that's what I'll finish with that in terms of this topic. Is there any closing observations either of you would like to make about this topic on social housing?
Well, I've learned that there is a difference between the different types of housing offered by the state and community organisations, which I didn't realise before.
Good. Yep.
Anything I say will take it off onto another tangent.
We don't want that, do we? We don't want that. That's fine. That's fine. Appropriate tangents are always to be commended. But given the hour of the night or day or whatever, I've lost track between day and night. I'm just going a bit mad at the moment. But anyway, that's fine. That's fine. So, all right. So that's social housing, topic 11. Let me just make some brief observations with regard to final assessment. Now, the final assessment, of course, will open next Wednesday, week 13. There's been a little bit of debate about timing of that. I won't change the timing of when it opens because that's been advised and that's clear. But just some indication about from some folk that they would appreciate a little bit of weekend time to deal with the final assessment. And look, I've taken that on board, and I probably will extend the due date or the deadline for the final assessment into the weekend rather than finishing on Friday to allow those people that want some weekend time on it because of other obligations and commitments. I think that's entirely reasonable given the timing of things at this time of the year. So I'll give you just everyone some formal advice about that, but the start time is not going to change, but a little bit of extension there with regard to the end time into the weekend. If you want to finish it before then, that's entirely a matter for you, of course. The final assessment will comprise two parts, as I've specified in the information document. Part A, there will be two discussion type questions. Those questions will be exploring conceptual ideas that have resonated through the course, basically. If you've been this is for everyone listening to the recording, if you've been hearing how we've been discussing things, if you've been seeing the strategies and the focus of how I've put the course together and how things I've emphasised in the notes and so forth in terms of abiding ideas, deeper concerns, underlying motivations, interconnections between areas of law that touch upon this area of land and interests in land. These are the, in a way, the things that are going to be potentially there for you to engage with in the choice of one of two questions in Part A. Equal value, 20 marks. Yeah, that's basically what I want to say about that. Part B, there will be one, I think it's fair to say, relatively complicated problem-solving question that will traverse a few areas. I mean, it's hard to say it's specifically about this topic or that topic. It will traverse a few of the topics in the latter part of the course. Of course, it's invariable. You design any problem scenario or factual matrix in a course like this that doesn't sit on the back of some presumed learning, for example, about the torrent system, for instance. I mean, that's just inevitable. You can't get away from that. It's not really, there may be aspects in which it touches on things that we've looked at previously, but hopefully the focus is a little bit different. Be guided a little bit by the fact that think about even before we got to some of these later topics earlier in the course, we saw that the instruments and the mechanisms whereby the issues were being tossed up were how people did things. You had an interest in land by virtue of a transfer and the lodgement of the transfer, or an instrument via a lease, for example, as you've seen in the moot assessment, and how that works. And of course, the lease creates, there's a leasehold interest and a proprietary interest and so on. So the mortgage, which has been tossed up repeatedly, of course, as even very early in the course when we were looking at just torrens and ideas in torrens into feasibility. Even then, we were looking at potential mortgage scenarios, and we didn't really fully know then what, from a land law point of view, what exactly how we were to understand this. But even then, we were looking at mortgage situations involving mortgages. So these property law instruments, they come into the mix. It's very hard. You have to. They're the basis of how you understand rights, entitlements, and interests in land merging and being transferred and being secured and so on and so forth. So, you can anticipate in some way, somehow, some of that featuring. Hopefully there's a few turns and twists there to keep you occupied. We wouldn't want you to be too bored in the process. Just remember that, and that is worth 30 marks. So the discussion question is worth 20 marks, and the problem-solving question is worth 30 marks. Just remember, it is in the nature of a take-home exam. It's not. We don't call it an exam, final assessment. We know it's, for practical purposes, in the nature of a take-home exam. And even though I'm not being, as clinical with timing as I think some of my colleagues may be, because I'm happy to be a bit flexible around that, just remember it is that. It's not an assignment. So I'm not looking for you to produce, 10,000 words, for goodness sake. It's not that's not what's required. But I am looking for of course, detailed, considered analysis and show me that you've got a good command and grasp of the law. You need to source that and show me the law that you're using, of course, in the normal way. The case law and the legislation is appropriate, and we know that in Queensland, the central legislation, the Land Title Act and the Property Law Act, figure prominently through most of the topics that we've considered in this course. But it's also true to say that very often we've got a tableau of law that's drawn from both legislative provisions, common law and equity that's in the mix in determining the rights and responsibilities of the parties with respect to a particular lot or an interest in a lot under the Queensland situation. And that's, of course, which makes land law both, in my view, more interesting and more exciting. Got to be excited, people. Got to be excited about land law, but also more challenging. Absolutely, its breadth and its absolutely. I accept that. So that's really, what I can say at this stage. Do your best. I know you will. That's both of you here and those listening to the recording. Let me just say this, that land law and property law generally is, and I'm not trying to be self-serving in this sense, please don't take this as in that way, but these are challenging areas. It's a challenging area of law, and for various reasons. And land law is a difficult and challenging subject. I think it's a fair point to make generally. I think most of us would recognise that. Even my colleagues outside of land law would recognise that. But I just wanted to say that I've been really encouraged by the effort that many of you in the course have put in to the course. Now, not everyone has been able to attend the tutorials, the classes, for various reasons, and that's understood. Actually, going forward, when I offer this course next time, I'm actually thinking about, adding a class participation component as I have in my other property courses. But that's for next time, not for now. But I've really been encouraged by really the depth of analysis and the competence that's been shown by many of you in grappling with the challenging problems and scenarios that I've put to you. I know that the first quiz was a bit of a challenge, or the quiz rather was a bit of a challenge in different ways. But many of you rose to the occasion, which was really encouraging. And look, at the end of the day, as students of law and then as subsequent practitioners of law, in whatever way that you're going to be a lawyer, either in conventional context or in whatever situation, the intellectual skills of understanding the law, its dimensions, and what it can achieve and how it can achieve its purpose of understanding the rights and responsibilities and obligations of people that are drawn into a relationship, and in this context with respect to land and interests in land, and how we balance private interests with public concerns, with social purpose, and with the broader intentions of the society and the law to maintain appropriate standards with regard to conduct and dealings between persons in relation to their transactions and how they express their entitlements to land and so on. All of this is something that you, going forward, have to embrace but you need to do it with an eye to being practical and pragmatic, and how ultimately that can be put into the service of serving those who you work in the interest for. And that can, you know, your clients, the community, it may be the government of the day, wherever the environment is that you end up working as a lawyer. And I think that many of you will find that property law and land law are foundation stones. They're not necessarily, it's understood, you know, the most exciting or the most jazzy courses on the curriculum, but they are the foundation stones, and very often one's experience starts in that area. It may progress on to other things that are more interesting, more exciting, but good grounding in this area stands one, in my view and in my experience, in very good stead. So, with those remarks, people, I wish you all the best for the final assessment, and I look forward to reading your final assessments when they are submitted. There will be a portal created on the Moodle website for the submission of your final assessments, and that will open when the assessment opens on Wednesday in week 13. So all the best. Any final comments?
Thank you very much.
My pleasure, Aisha.
I really appreciate it, Michael.
My pleasure.
Have a good night.
Grant, did you have something?
I was just saying thank you very much.
Yeah.
As much as both foundations and this course, and in fact the other course that I'm doing with you, as much as that has been particularly challenging, I have thoroughly enjoyed the courses.
Oh, that's great. I appreciate that. And look, that's what, it has to be about that, right? It has to, in my view, you know, your law studies taking you through a number of areas of law as they must do, but for goodness sake, it has, you know, we have to find ways to make our education and our learning and our growth as lawyers interesting and dynamic and vibrant. You know, that's my personal belief and commitment, and you know, certainly want that to be the experience of my students as much as possible. So yeah, so all the best, people, all the best.
Thank you. You too, Michael.
Bye for now.
Good
Bye
night.
for now.
See you, Grant.
See you, Asha.